maybe the only thing good that came out of the pandemic is the technology of Zoom and all that everyone's kind of hopping onto it. So it's pretty cool. All right, it's 7:05. I think we should get going. For all of you who don't know, I am John. I'm the senior manager at Cummins Property Management. Tonight we have Kevin Hirzel. He's the managing member of Hirzel Law. He's got a resume of like 6 pages long, so I'm sure he could fill you in more of that. But he's been obviously you check out his website. It's an amazing website with everything they do there. He's been on CNN and all that stuff. And what is it? I'm trying to remember all my Jeopardy questions. The up and coming young attorney of 2020, and you got a number of them at your office. Your attorney's firm there. So I guess what I'm trying to say is he's very well qualified. So probably one of the best, if not the best, a condo attorney in Michigan. So other than this topic he has tonight, he emailed me like 6 topics and all of them sounded awesome. So we're gonna make sure he comes back for us maybe in a couple of months and we can do this all over again with a different topic. But so before we get started, Kevin's going to go through his PowerPoint slides, and then we're going to hold the questions to the end. You can put the questions in the chat box as we go, just so you don't forget them. And then, so at the end, I will try to go sift through the questions in the chat box and ask them to Kevin. And then we can open it up to more questions at the end too. So, other than that, I think that's all I had here. So we appreciate everyone being on and being with us. So with that, I will turn it over to Kevin.
All right, great. Thanks for the warm welcome, John. Thanks to Cummins for having me, and hopefully you guys have fun and learn something today. So this presentation is called "So You Joined a Community Association Board, Now What?" This is something I developed as just kind of like an onboarding training type of deal. For new board members. This is one of the few volunteer positions, jobs that you'll ever have in life that you probably have very little training for. Most of you showed up at an annual meeting. People probably begged you to be on the board, or you raised your hand and didn't know exactly what you're getting yourself into. So the purpose of this is really just to kind of cover the basics, go over some pitfalls of common issues, how to avoid them, and set you guys up for success and how to operate your condominium associations and homeowners associations. So just the basics of what a community association is. And we have condominium associations in Michigan. We have homeowners associations. We have John's favorite association, which is called a summer resort. There's a few of those. We have co-ops, but they all share some fundamental concepts. So in one sense, this is a piece of real estate. It's an investment for all of you guys. So you want to protect your property values and your investment. To some extent, it's kind of like a government in that you have rules that you have to enforce, kind of like a city, county, federal government. And it's also a society. You guys have to get along as neighbors and figure that part out, because everybody wants to live in a place that's enjoyable and has a shared sense of community. So the overview of what we're going to cover tonight in order to sort of facilitate how that all happens is, what are the governing documents and why are they important? What are the different types of meetings and how do you legally take action and make decisions? How do you enforce the governing documents? And then there's some bonus slides I put together are Herzl's hurtful mistakes to avoid, which are just some common issues that I see come across my desk that may not necessarily have a common sense solution. So we're going to go over some scenarios there and what's the best way to address them. So we're going to go ahead and start off with the governing documents here and walk through what each of those are and why they're important. So whether you are a condominium association or a homeowners association, for the most part, you're all going to have articles of incorporation. There's different types of entities that we have here in Michigan. So we have nonprofit corporations. Those can be organized on a membership versus a directorship basis. We have for-profit corporations. We have unincorporated associations, and then we have voluntary versus mandatory associations. So for the most part, I would say, 99% of you are going to be nonprofit corporations that should be organized on a membership basis. And what that basically means is that the people that buy into your communities automatically become members. There's something in the governing documents that's recorded that says by virtue of them owning this piece of real estate, they have to become members of this corporate entity. Okay. Sometimes I've run across situations where it's organized as a directorship basis, or that's in the Articles of Incorporation, which is not necessarily correct. And that's something that should probably be corrected if you see that in your Articles of Incorporation. For profit, you guys are not in business to make profit. You're nonprofit, and your sole purpose is really to administer and operate your community here, enforce the documents. So that would not be an appropriate selection. So if you have a for-profit, you're going to probably want to convert it to a nonprofit. Unincorporated is not necessarily a great choice because anybody who's running that, you do not have a corporation, you are exposed to significant liability, and we're going to get into the different liability protections that are available to nonprofit corporations. And then voluntary versus mandatory, I would say the vast majority of associations that are out there are going to be mandatory associations, but there does have to be something that's recorded in the Register of Deeds that mandates that a property owner has to be a member of the association. Occasionally, you'll see something that was formed after the fact, and there's nothing recorded that mandates a property owner has to be a member of an association, and that's going to be called a voluntary association, but those are fairly rare. So this is something, if you want to look at what these documents are, I'll make the PowerPoint available to John to send out afterwards. There's a website State of Michigan has here, and it has your Articles of Incorporation, which is the document that actually creates your corporate entity. So that's going to be up there. If you have any amendments to the Articles of Incorporation, that will be up there and that will be available. And the other thing that you'll see when you go through there is if you filed an annual report, you're required to do that to each year, which is basically your notice to the government that says, hey, we're here, we still exist, we're still a corporation, we want to maintain our corporate status moving forward. So that's how the corporate entity itself is formed. When you take a look at the Articles of Incorporation, there's some key aspects that you're going to want to make sure are there. A lot of times when the developer does these, if they've never been updated, they're less concerned about this just because they want to sell units, get out of the project, and they're not concerned about the long-term operations. In other circumstances, there's just been a lot of changes to the Nonprofit Corporation Act, in the last 5-10 years. And so some of these issues that we're talking about may just not have been around when your Articles of Incorporation were drafted. But you want to make sure that you have a corporate purpose, who are the members and what power does the association have. That should be outlined in there. I've seen a few times developer documents get sloppy and they'll basically identify the wrong condominium, the wrong subdivision that they're supposed to administer. So you want to make sure that the corporate purpose is in there, that it's accurate, that's required. For membership, it should identify who the members of the nonprofit corporation are. One thing that can get a little bit tricky here that you're usually going to see here somewhere in the corporate bylaws is somebody that doesn't necessarily have legal title to property. Can they be a member? And that commonly comes into play when you have a land contract, whether the person who's purchasing or selling under the land contract where title hasn't necessarily passed yet, who is the member? And you can define that in your documents. One of the most important aspects of this is going to be limitation of director and officer liability. And we're going to get into that a little bit later, but that defines the standard of care and what kind of standard of care that you would need to breach if somebody were to sue you or be able to sue you, and whether the association is going to step in and pay for a defense, or pay for a judgment. That gets into indemnification. One of the key aspects is that you maintain your volunteer status, because under the Nonprofit Corporation Act, you can put in indemnification for directors, officers, and volunteers. So it's important to make sure that you have that in there as well, and that works in conjunction with directors and officers insurance. Another big thing that you want to look for, and sometimes this is in the corporate bylaws, but often in the Articles of Incorporation, is can you take action without a meeting? And so when the members need to vote on something, especially document amendments, oftentimes it is convenient to make sure that you can just send out ballots and collect ballots as opposed to get everybody together at a physical meeting and vote. So that's an important provision to look for. And then one of the newer provisions is basically, do your documents, do they contain a compromise or a plan for reorganization amongst creditors if you ever had some sort of financial issues? So these are there's other aspects to it, but these are kind of the highlights, the key components to take a look for. And then I'm going to give you some examples of how this may come into play in the real world and why these provisions may be important. So the first scenario I'm going to give you is that we have Jojo Brown. He's the president of the Virus Valley Association. He's on the board with Joe Manwich and Kristen Cinema. Jojo Brown wants to beef up the infrastructure and repair the road in his condo. In 2-to-1 decision, the board votes down Jojo's Build the Road Back Better plan. Jojo consults with the association's attorney, who advises Jojo he can enter into a contract with the road company anyway, since he is the president. Jojo enters into a contract for $1 million. Joe and Kristen sue Jojo. Is Jojo liable for the $1 million here? So, we have a situation. He was obviously in the minority of the board. He went ahead and did something that he wanted to go ahead and do anyways. The I guess interesting factor, the key fact here is that Jojo went to the association's attorney and got some advice that he relied on. And I think most people would recognize that, he probably made the wrong decision there. But in making the wrong decision, it was based on the advice that he got from a professional. So when you're making major decisions that could be subject to a lawsuit, or you think somebody may second guess them, it's important to rely on the advice of counsel, and that's under the Nonprofit Corporation Act. There's something called the business judgment rule that basically says if you go get an opinion, from an attorney, that you can rely on that in making a decision, and then the board is not going to substitute its judgment or second guess that. That's not just legal advice. That holds true for any kind of professional, whether it's an engineer, an accountant, anything along those lines. So it's important that if you don't know what the answer is, that, in order to protect yourself and avoid liability, go ask for some help, get a professional opinion. And that's just something that's standard under the Nonprofit Corporation Act to get people to serve on boards and to provide protection for people that serve on nonprofit boards. The other key thing that I would note here as far as avoiding liability is enforce your documents as written. A lot of times I see people, they don't ask for advice, or they will create, just sort of standard practices, or just say, well, the documents don't say this, but this is the way we've always done it in our community, and so we're going to keep doing it that way. Generally speaking, the way that I find people get into the most trouble is they deviate from something that is in the written governing documents. They don't get advice from professionals. And then when you mix those two together, that's just kind of a recipe for trouble. So those are the two best things that you can do there in order to avoid liability. When we take a look at director liability here, give you another example and sort of see how this one kind of comes out here and what kind of limits there would be on director liability. Scenario is you have Jojo's head explodes after the Build Back Better lawsuit. Bylaws require the association to carry $2 million in insurance. Joe and Kristen previously voted 2-to-1 to reduce the association's insurance coverage from $10 million to $1 million. Clubhouse burns down and costs $2 million to rebuild. Board votes 2-to-1 to levy an additional assessment for the extra $1 million to rebuild the clubhouse. Jojo, who's unhappy, he sues Joe and Kristen for breach of fiduciary duty. Are Joe and Kristen liable? So, here they clearly made a decision. It cost the association, and it's going to cost the co-owners a lot of money because they made a wrong decision about insurance. And whether they're liable or not is, generally speaking, going to depend upon the language in the Articles of Incorporation and the standard of liability that was chosen by that particular association. So if you have no language in there about director protections, the standard of care is basically going to be negligence, which is, did you have a duty? Did you act reasonably, under the circumstances? Okay. One of the changes that came in 2015 is eliminating money damages for director liability for up to gross negligence. And so that's basically a significant departure from the standard of care. Essentially, what the Nonprofit Corporation Act said is that you can more or less eliminate liability except for the 4 things that we have here on the screen, which is if you receive an improper financial benefit. So if you steal money from the association, you can't protect yourself from liability for that. If somebody can prove that you have intentionally harmed the corporation, its shareholders or members, as opposed to something that was in a gross departure from the standard of care or an accident, but that you intended something bad to happen to the association or the members as a result of a decision, which is difficult to prove. If you committed an intentional criminal act, or if under a derivative action, there was a potential award for attorney's fees. But other than that, if you wanted to eliminate liability for money damages for volunteer directors and officers, you can go ahead and do that. So make sure, since you've joined the board, you at least take a look at that document, understand what the standard of liability is. To update these documents, from a drafting cost, it's relatively cheap. It's usually like somewhere between $600 and $800 for us to do that. So if it's outdated, this is a simple fix. There's not a ton of customization, but you just need to be aware, if you are on the board, what your potential risks are, and that you may have more potential risk if you don't have certain language in your documents. The other key thing here to take a look at is indemnification. And so what we previously discussed was, what is the standard of liability? So indemnification basically deals with a couple different things. One, is there going to be an attorney? Is the association going to pay for an attorney? And number two, if there was a judgment that was levied against the board member, who's going to pay for that? Are they going to be individually responsible or not? So generally speaking, the first line of defense here is to make sure that you have what they call directors and officers insurance. And so a lot of times the insurance carrier will appoint attorney to defend a case, and in certain circumstances they would pay out a judgment. There's a lot of different exclusions, though, to insurance policies, and so they do not cover everything. And depending on what you get sued for, you may run into a situation where it's not covered by insurance. And so in that circumstance, it's really important to make sure that you have indemnification provisions in there. And essentially what that's going to measure and what you can be indemnified for is, whether you were a volunteer, you were acting within the scope of your authority. So once again, staying within the bounds of the documents, you were acting in good faith. Indemnification is not available for gross negligence. You can cut off your liability, as we previously discussed, but you can't be grossly negligent or essentially intend something bad to happen, that was not intentional. And, there's no indemnification for motor vehicle accidents because that's going to be covered under no-fault insurance. But otherwise, it's important to make sure that this is in here. The other thing that, was a change in the last 5 to 10 years here, it was making sure that committee members would, if you have people that, are in a landscaping committee or trying to help out along those lines, that they'd be entitled to these protections too. But you need to make sure that that is specified in your documents as well. All right. Some of the key aspects that you want to keep in mind about the directors and officers insurance that we talked about, they come with a couple different things. Is the duty to defend, which basically what they're going to take a look at there under an insurance policy. Is there any claim in a complaint that is arguably falls within coverage? So when they initially get the complaint in and review that, they say, is there anything that we may have to pay out depending on how this shakes out? So if the answer to that is yes, that if there's anything that's arguable that could come within coverage, then that triggers what they call the duty to defend. That means that the insurance carrier has to appoint an attorney. Then there's also what they call the duty to indemnify. So that's much more narrow. So that means when you get to the end of the case, is there actually a covered claim that the association's insurance carrier would have an obligation to pay out? Generally speaking, in these circumstances, make sure you have D&O, make sure you understand what it covers. Not all directors and officers insurance policies are created equal. For some of them may provide a defense for a breach of contract claim or not. Some of them will not provide coverage for insured versus insured if one director sues another or something along those lines. And so it's really important to talk to your insurance agent about this. But this is something that you don't want to skimp on or save, $500 or $1,000 here or there. It's really important to have good coverage. Just because I've seen a lot of situations where people have not had this and they've had to pay a lot of money out of their pocket, to pay for an attorney to defend themselves. So the other thing you want to take a look at when you're reviewing insurance or talking to your insurance professionals is whether the insurance is occurrence-based or whether it's claims made. Occurrence-based, you're going to get much broader coverage. So basically, the lawsuit, the claim itself, and the action that brought it about, if it's claims made, then that all has to happen within the policy period. Occurrence is basically broader, that as long as the action that resulted in the lawsuit occurred during the policy period, even if you were to be sued outside the policy period, there would still be coverage for that. So a lot of times, people may wait a year or two to sue. And so that's why it's important to make sure that you guys having occurrence-based policies, which most insurance professionals are going to sell you, unless they want to try and sell you something that's a really cheap product. The other thing to keep just in mind is that, a lot of claims or issues that we're starting to see arise, that a crime policy is going to be separate and apart from your standard general liability or D&O policy. Sometimes it's called a fidelity bond or cyber insurance policy. But a lot of things related to social engineering, if one board member, their email got hacked and they sent, and the board president sent an email to the property manager that said, pay this vendor $50,000, and it went to a fake company and a fake account or something along those lines. That's why you need that type of insurance to cover that. It generally is not going to fit into D&O. And so that's just another thing to keep in mind and talk to your insurance professionals about as well. So for the remaining governing documents, moving on from the Articles of Incorporation, for condominiums and HOAs is what we're going to focus on. For condos, you are going to have a master deed. And that's essentially the document that is recorded in the Register of Deeds that is going to define what your common elements are, who has certain maintenance responsibilities. It's going to have the legal description of the condominium, how can it be expanded, not expanded, and it essentially deals with the real estate and maintenance of it. The condominium bylaws is really going to deal more with the governance type of issues. And you're going to see things in there related to how you collect assessments, all the different restrictions, what people can and can't do, how to have meetings, what are the requirements for that, what are the requirements to be a board member, and those types of things is typically what you're going to find in the condominium bylaws, which have to be attached as Exhibit A to the master deed. Exhibit B is going to be what they call your condominium subdivision plan. The modern trend here with respect to the bylaws is to combine them together in a single set. Some older documents I've seen is that it's permissible, but they would have separate corporate bylaws that deal with, how to run meetings, who can be the president, who the officers are, how to recall board members, things like that. As far as just governance issues under the Nonprofit Corporation Act, it legally can be separate. It's not something I recommend, and if you have separate ones, it's sort of inconvenient because the condominium bylaws always have to be recorded, the corporate bylaws don't, and so sometimes they can get lost or changed over the years and that kind of thing, and it's just easier if you have a single set of documents that you can reference and everybody can go to. With respect to HOAs, we don't have an HOA Act here in Michigan. We do have a Condominium Act. So HOAs are largely a creature of contract. What you're going to see is restrictive covenants, deed restrictions, declarations, sometimes it's called a declaration of easements, but that is essentially the equivalent of your combination of master deed and condominium bylaws under the Condominium Act. Those are also going to be recorded in the Register of Deeds as well. Generally speaking, HOAs, they will have separate corporate bylaws. Those will not be recorded. If you really wanted to, you could do a combined set there as well. But generally speaking, those are going to be the different governing documents that you are going to be required to be familiar with and are going to be used to operate your community associations. So what do you want to look for in the master deed? What should that have? Why is it important? You want to make sure that you have the correct legal description of the condominium. That has to be in the master deed. It's required. I've had a few times where whether it's just through sloppy drafting or something else, or mistransposing numbers or words that you don't have the correct one, and that's led to disputes about where boundary lines are, property lines, things like that. So it's important to make sure that you have that in there. It's correct. You should make sure that you have the correct number of units in there, and that matches up with the number of units in the condominium subdivision plan. One of the most interesting cases I had before was a unit, whether it existed or did not exist, because it was not drawn on the condominium subdivision plan, but it existed in the text, and then it was foreclosed on by the county. And then, the dispute was whether this unit existed or did not exist. So that's something that's important to take a look at. The common elements, understanding whether they're limited or general, and are the responsibilities of repair clearly outlined. Generally speaking, general common elements are for use by everybody, and those are going to be maintained by the association. Limited common elements, those are going to be used by less than all of the co-owners. Oftentimes that will be one co-owner if it's like a deck or a driveway or something like that. Sometimes it will be multiple co-owners if it's a carport, for example. And making sure that the responsibilities for repair are clearly outlined. Association typically has to take care of general common elements. Sometimes they have to take care of certain limited common elements as well, but that's all going to be outlined in the documents. And if there's overlap or confusion, that's something that should be clarified through an amendment. So that's really going to be your, Bible when you go back to the owners as to, who is responsible for what. In identifying, association versus co-owner repair, because that's one of the, major areas of dispute that we often see. So it's also important to make sure that the insurance provisions line up for that, because a lot of times you'll see something, there'll be some sort of an event or an occurrence, and the responsibility for repair is not the same as insurance. And then there's a dispute between the adjusters and the co-owners about who's responsible for what. So in older documents, I would typically say the association it tended to probably overinsure. And you can save money for the association on their insurance policy by drawing, just kind of clear lines down the middle and delineating co-owner insurance and association insurance and association responsibility versus co-owner responsibility. And having very clear lines there, it avoids disputes, and it's really going to save on insurance because you're not going to have overlapping coverage. One of the other big things to take a look for in the master deed is the percentage of value. It's required to add up to 100%. Percentage value can be used for different things, though. So it's always going to be used to identify the percentage of ownership of the common elements. What the Condominium Act says, though, is that you cannot transfer those separate and apart, so they just go with the unit as part of the ownership. They can be indicative of voting, though, and voting rights. Sometimes everybody has equal voting rights. Other times, if there are larger units and they have a larger percentage of value, the documents will indicate that somebody has greater voting rights if they have a larger percentage of value. Same holds true for assessments. Some documents will say everybody pays equal. Other documents will indicate that assessments are based on percentage of value, and some people have to pay more or less based on what that percentage of value is. Master deed is going to outline easements and basically whether there's easements that benefit the condominium, or does the developer still have any rights? Can they grant easements through the condominium to a different project is often going to be outlined there. And then amendment requirements. Sometimes I've seen people just put incorrect amendment requirements in there. It does have to track the Condominium Act, which requires 2/3 co-owner approval. And there's 9 different things that require 2/3 mortgagee approval. And then there's also, in some circumstances, developer consent, or I've even seen municipal consent is required. So make sure that you take a look at that. It tracks the Condominium Act, and that you don't have anything that says that you need 50% or 80% or anything along those lines. All right, so for the condominium bylaws and the covenants, what are kind of the typical things that you get into here? And this is kind of what I talked about at the beginning, the society relationships and sort of the governmental operations aspect of the association. This is really where you're going to find the restrictions of what you can and can't do, in short. So you're going to find the architectural control provisions, whether people can make modifications to their units, what the approval requirements for those are, whether it needs to be written, what needs to be submitted, all that kind of stuff is typically going to be there. You're typically going to find a provision related to assessments and how to collect assessments and what the penalties are if assessments are not paid. You're going to find insurance responsibilities, what kind of insurance the association is required to carry, what kind of insurance that a co-owner is required to carry there, whether that is mandatory or not. We typically recommend making insurance mandatory for everybody. We've had some scenarios where units have burned down and it hasn't been, and there's been problems because some of the owners did not have insurance. or for contents and other types of things. Leasing and rentals is a big thing that you're going to find in here, whether short-term rentals are allowed, what kind of notice has to be provided, whether you have a rental cap, all that kind of stuff is what you're going to find here. We'll call it nuisance smoking and smells. There's typically going to be a provision that basically says you can't do anything that's going to be illegal. You can't do anything that's going to generally annoy your neighbors. Some people have specific smoking provisions, some people don't. And so those types of things, depending on what types of issues you're having, there's at least a general provision. Some of documents are going to be more specific than others, though. Parking, vehicles, and towing is another big thing that we typically see in there. Pet restrictions, what you can have as far as animals, how many of them, types, that kind of thing. Technology provisions. This is one I see most developers don't necessarily put in there, but is becoming more of an issue that, there's just, the world is changing. And especially if your documents were written 10, 15, 20 years ago, they would have never contemplated that we would be on Zoom right now, or that drones would exist, or, things of that nature. So, drones, electric vehicle charging stations, what are the parameters for having those? Not hacking into somebody else's Wi-Fi or community Wi-Fi rules, bringing smartphones to meetings, whether they can be recorded, not recorded, social media use, whether you can create, fake, something that came across their desk just yesterday, we've seen a lot of times is, realtors or somebody else creating a fake association page or a Facebook page that's not authorized by the association. Solar panels, whether those can be installed or not. So it's another big thing that we're seeing a lot of. But these are, typically this is where you are going to find the meat and potatoes of a lot of the issues that are going to maintain property values, but may also cause issues in interactions with your owners. The last thing that you need to be aware of is rules and regulations. And so I'm going to sort of go over an example here because a lot of you will have rules and regulations and may wonder, well, what's the difference between a rule and a regulation and, the bylaws? So we have the Virus Valley Association. The bylaws require the association to maintain, repair, and replace the limited common element front door of each unit. The bylaws also permit the board to adopt rules regarding the appearance of the condo. The board adopts a rule requiring all front doors to be painted brown at the co-owner's expense. Mitch refuses to paint his front door brown. The association sues Mitch. Who wins? Well, the key thing that you need to take a look at with respect to the rules is you always need to find a way to tie them back somehow into the bylaws. So what a rule can do is implement something that exists in the bylaws. So for example, you may have a provision that says somebody gets a lien on their property if they don't pay assessments, which is pretty common. The bylaws may not spell out the process as to exactly how that works. So you would adopt a collection policy as a rule that, for example, would say after 30 days, the owner would get a letter from the management company. After 60 days, they get a letter from the attorney. After 90 days, they would get a lien. They still didn't pay, after 120 days, it would go into foreclosure. So that would be an example of actually implementing the bylaws or doing something that's in the bylaws. This actually came about from a real case that went up to the Court of Appeals. And the Court of Appeals said that this rule was not enforceable. And the reason that this rule was not enforceable is that it changed the substantive rights and required the co-owners to do something that they didn't have to do under the condo bylaws. So the issue here was that the association was responsible for the maintenance of these doors, even though they were limited common elements. And they basically said, you can't make the co-owner pay money out of their own pocket to paint their front door brown when you have that responsibility under the bylaws. So they said that was an inappropriate use of rules. So just keep that in mind when you are adopting rules. You can't change substantive law or anything substantive about the bylaws. You got to tie it back in and use it to implement or fill gaps in the existing bylaws. Just some quick signs that you may want to take a look at your documents and whether they need to be amended. If you're in a condo, master deed and bylaws are pre-2002. We've had some, amendments to the Condominium Act, not super significant since 2002. They may require minor updates, but if you haven't had them amended since 2002 and you're in a condo as opposed to a homeowners association, you're probably going to need some significant updates in order to track the act. Another big thing that we see as far as when your documents may need to be updated is if they've never been updated after developer turnover. A lot of the issues and the restrictions and stuff that we talked about those are not going to be in there because the developer isn't super concerned about staying in the project for a long time. Also, a lot of the developer rights will need to be sucked out to make sure that, if somebody comes in and tries to buy a lot of units or get an assignment or something like that, that you are not going to have somebody come in and, for example, say, well, I'm a successor developer, I now own 10 units, and under the documents, developer doesn't have to pay assessments, so I don't have to pay them. So we want to avoid those types of disputes and clean that up and make sure that the association is well positioned to operate. Technology, as we went over, is a real big thing that if you're not prepared to deal with those types of issues, it's better to put that into your documents and fix them now and be prepared to move forward than find out the hard way through a lawsuit. Other big thing I see is that if your practice and what you do in practice differs from the actual language, that's a good sign that you should amend your documents so that they actually track what you're doing in practice and the procedures that you're implementing. One example of that may be that the association is responsible for replacing everybody's window. And if there's an issue with the window, they're responsible for it, but historically the co-owners have paid for it. So that's a disconnect from the documents to what's actually happening. So if you have those types of issues, I'd recommend updating your documents or either conforming, changing the practice. Conflicting provisions, stuff that's confusing that you don't understand. I'm personally a firm believer that, documents should be written for co-owners and for them to be able to understand, for board members to understand. You shouldn't need to go to law school. You shouldn't need to have a law degree to be able to decipher what's in the documents. And so if you have stuff that is just, run-on sentences, things I've seen sentences that are like a half of a page in some of these documents. And it's confusing, it's hard to read. So if you have stuff like that, that's just not understandable by people in your community, you should consider an update. And then if you just have no limitations on liability and have a lot of personal exposure, that means you're also probably a good candidate as well. If you're not sure whether you need anything, real quick before we move on to meetings, we offer a document review. So part of what we have, like with our standard package here, it's for $1,500. There's a variety of services you get, but as part of our premium service plan is basically we'll give you a condo report card. So we will go through, make sure you have all the legal requirements, best practices in your documents, check boxes, yes or no. Put that in layman's terms so it's simple for you to understand. If we see anything else along the way, we make notes. So at the very least, you have an idea on where you stand with your documents, what potential holes there are, what you may encounter in the future. And if you don't have it in your budget to update it right away, that you could build that into the future to make sure that you have a good set of documents that's going to be able to take you into the future. All right, so we're going to move on from what are the basic documents to the different types of meetings and how you can successfully run a meeting and avoid trouble there and what needs to happen at a meeting. So one of the big things that you guys are going to encounter, and one of the most challenging things, is going to be the annual meeting or a meeting of the owners, trying to get everybody together, making sure everything operates appropriately, making sure that you're running the election correctly. So the big thing to take a look at here is what's the record date, and that's going to determine voter eligibility. So the documents in the Nonprofit Corporation Act, they're going to require that you provide notice of that meeting. And that's something that Cummings is great at, is definitely getting all those meeting notices out, making sure they're accurate. And you as the board, to some extent, have a decision to make or not to make is to voter eligibility. So by default, if you do not decide on a record date as to when somebody is eligible to vote, it is the day before that notice goes out. That person must be, current on their assessments, or some documents will say that you have to be in compliance with bylaws. Whatever the voter eligibility requirements are, if you as the board do not set a record date or a date to determine when somebody can vote, that's what it is by default. What you can do as the board is basically say, we're going to set a different record date, that if somebody wants to come and they want to pay their assessments, that they're allowed to do that, and if they do it by a certain date, then they're going to be allowed to vote. So you need to make sure that you give everybody notice of the meeting, and you need to decide what that record date is. and that's determinative of who can vote. The other thing that I see at the annual meeting sometimes that gets a little bit confusing is not understanding the difference between a director and an officer. So when you go to the annual meeting, you are electing directors. So some people will come to me and they'll say, well, I went to the annual meeting and I was elected as the president of my association. And I have to tell them, no, you were not. It's very rare that you'll see that officers are elected by the membership. The vast majority of the time, what they do is they'll elect, 3, 5, 7, however many directors or documents require. They do that at the annual meeting. Then the procedure that's supposed to take place is those directors, they get together in their first meeting, they decide on who the officers are. The bylaws are going to indicate what the requirements are to be an officer. So sometimes you have to be on the board of directors, sometimes you have to be a member of the association, and other times you don't. It's most common that all the officers are also directors. They don't necessarily have to be. That's going to be dictated by your bylaws, but the board of directors themselves is going to be responsible for picking who those officers are, appointing them, and removing them. All right, so for board meetings, same type of, you're going to have notice requirements that need to be complied with in your governing documents as well. Make sure that those are complied with. You want to make sure that you keep good records. And I'll just tell you that for Fannie Mae and Freddie Mac, they just came out with some new financing requirements. And basically, any kind of traditional, bank that you're going to be, going to get a mortgage to buy a condo unit, they all want to sell their mortgages to Fannie Mae and Freddie Mac, so they follow their guidelines and their requirements. One of the things that they have asked them to start doing is taking a look at board meeting minutes and attached condominiums to figure out if there's maintenance issues. So if you don't have those records, you're legally required to keep them under the Nonprofit Corporation Act, but if you do not have those records, it may interfere with the ability to sell units and impact your property value. So make sure that you're always keeping a record of what goes on, and those are the meeting minutes that are going to be taken by the secretary. Generally speaking, as we talked about, electing officers is something that's going to be a board function. The other major things that come in front of the board that you guys are going to have to vote on is, architectural approvals, what the budget is. You set that once a year, and then that sets assessments. Contracts, that's something that you guys should vote to approve on. Enforcing restrictions. I mean, there's a variety of other decisions, but the key thing here is that you need to have quorum, you need to have a majority vote, and you need to document those decisions. All too often, I'll just see, somebody say, well, I'm the president, so I can go ahead and enter into this contract. Well, that's not the way that works, unless the board has somehow given them authority to go enter into that contract. So, keep that in mind, that, as long as you guys are staying within the concept of, majority vote rules, that is generally the way that this is going to work for the most part. So that's how board meetings work, and make sure that you keep good records and just document the decisions that you made. When you document in the meeting minutes, you don't necessarily need to write a book of what everybody said and what their opinions are. Really, what the important thing to keep track of is who voted for what and what the outcome of the vote was. Was a motion made? Was it seconded? Did the motion pass or not? And so that's really what the function of boards are. And some of them meet monthly, some of them meet quarterly. You just, depending on your community, you have to figure out what's a good cadence for you. All right, so some questions about board meetings here. So we have the Virus Valley Association. They can't convene a board meeting. Jojo does not want to be in the same room as Joe Manwich after he tanked his Build Back Better plan. Jojo proposes the following options for the board to start making decisions. Conduct all votes via email and do away with board meetings. Allow board members to participate in a telephone conference. Allow board members to vote by proxy. So the question is, are any of these viable options? So we'll kind of go through this. In today's world, a lot of people just operate by firing it off an email and thinking that it's done. So the way it works under the Nonprofit Corporation Act is that you all can vote and approve something on the board via email, so long as you have unanimous consent. You then would have to attach that to the meeting minutes of the next meeting, and then it would be deemed approved. If you do not achieve unanimous consent via email, you can go ahead and take an advisory vote, but you would need to vote to formally ratify that at the next official board meeting that you have. So keep that in mind that, if it's a 3-2 decision or something like that, that you then need to formally retake that vote, put it in the meeting minutes at the next meeting, because otherwise you just sending emails back and forth would not necessarily count for that unless it was unanimous. So that can work in certain circumstances. Allow board members to participate via telephone. So this works under the Nonprofit Corporation Act, whether you want to have Zoom, whether you want a telephone, whatever it is, as long as there's some form of two-way communication, everybody has the opportunity to speak and communicate with each other. This is an acceptable way to hold a board meeting if you wanted to do it that way. Last one is allow board members to vote by proxy. So this doesn't work. So you can only use proxies at meetings of the association. You couldn't give a proxy and tell somebody else who's not on the board to go to the board and vote in your stead or to take action. So that doesn't work. All right, so one of the other biggies that you guys are going to have to deal with, once you get the basics down of how you vote is, what you vote on and how you enforce the document. So bylaw enforcement is probably one of the most important, yet one of the most difficult jobs that you guys are going to have to face as board members. So we're going to go through the different mechanisms that are generally available about how you would enforce the governing documents. So one way to do that may be through fines. Liens is another possibility. Money damages, if the association is out of pocket anything, may be a way to recoup some of your losses. We're going to go over injunctive relief and what that is and what a court can order for somebody to start or stop doing something. Recovering attorney's fees. This is a biggie. A lot of documents are going to allow the association to recover their attorney's fees if they're successful. But you want to take a close look at that to make sure that it's not just if you get involved in litigation, but if there's pre-litigation fees or you go to bankruptcy or something like that, that those types of fees are going to be recoverable as well, because courts will look at the specific language of your documents. A lot of the developer documents I see just says it's just the litigation costs and nothing more. So you want to take a look at that to figure out where you're at on it. And then we're going to get into the bylaw enforcement and collection policies. Those are things that are important for you to have in place so everybody's treated equally. You don't have selective enforcement problems. And essentially what that is we get back to you implementing what's in the bylaws. I kind of went over before what a typical collection policy is, but it's just to make sure that, your neighbor who you're good buddies with, just because you happen to be on the board, they don't get 2 years to pay their assessments versus the guy across the street who you don't really like. As soon as, he is 1 day late, that you are all over him and trying to send him to the gulag. So having these policies in place, it also takes some heat off of you as the board to being the bad guy and basically just saying, I don't really have a choice. This is the policy. Everybody's treated equally. Everybody goes through the same thing. And that's true for the bylaw enforcement, process as well, as we typically have a recommendation that, would start with getting a warning letter and then, having the variety of remedies that we're going to discuss here. So take a look at your documents. Some documents are just, especially in the homeowners association context, they may not have all of these remedies, which makes it a little bit more difficult to enforce the bylaws. And so the more tools that you have at your disposal, the better off you're going to be. All right, so fines. So this is one of the popular remedies, is people will say, we don't need to go to the attorney. Maybe don't need to involve the property management company. We're going to impose fines. So fines can be good for some things, but we're going to get into an example of how fines work and what you need to do in order to fine somebody. So we have Hunter Brown. He's an investor that owns 10 condo units. The bylaws are well drafted, most likely by the top-notch attorneys in Hirzel Law. The bylaws prohibit rentals for less than 6 months. Hunter rents his units on Airbnb on a weekly basis. Jojo says he knows nothing about Hunter's investments. Joe Manwich and Kristen Cinema instruct the property manager to fine Hunter $100 for each violation per the bylaws upon learning of the violation. Hunter does not pay the fine. The association places a lien for unpaid fine. Hunter sues to have the liens removed. Who wins in this circumstance? So one of the key things that I see boards slip up on is just they shoot off an email and they say you're fined. or they just make a decision even in the context of a board meeting just to find somebody. So if you live in a condominium, the Condominium Act says that you need to have notice and a hearing. So you actually need to invite the offending co-owner to a board meeting before you vote to find them. They don't have to show up at that meeting, but you do need to give them notice. You need to give them an opportunity to be there. If they show up, you can still vote to find them after hearing them out. If they don't show up, you can vote to find them. That's fine. We recently had a case went up. It's been back and forth with the Michigan Court of Appeals, but where it stands now is that we have a judgment against an owner that was based on 10 years worth of fines at $1,000 a month. And so it's a pretty hefty judgment that they're going to have to pay there based on fines. But the reason why it's been upheld in the court so far is that the association followed the correct process. They basically invited the owner, they gave him notice, he chose not to come, and they gave him notice that says, here's the fine schedule if you don't remedy this violation, and he didn't remedy it, he didn't complete his house, and the court found that to be reasonable. So make sure that you're just not clearing off fines, but that you do go through the correct process. It's important. I guess the last thing before we move on from fines to liens and foreclosures is that fines, they can be good for certain things, like for people that leave out their garbage cans. A fine is not necessarily a great remedy to stop a short-term rental, though, for example. So you're finding somebody that's renting, they'll probably just build that in as the cost of doing business, and the violation will go on. Finding somebody $25 because they're smoking marijuana and it's, causing all kinds of problems in the hallway or something else, probably not going to be an effective remedy. So just kind of keep in mind that you don't want to necessarily take a bazooka to kill a fly when a fly swatter will do, but you don't also want to take a fly swatter to a gunfight. So make sure that you understand that the remedy has to be in proportion to the violation as well. It's an important thing to keep in mind. So and that's something, if you ask your attorney, whether it's us or anybody else, and even the property management company, they'd be able to provide you some guidance as to what's the best way to actually resolve this problem, whether a fine is an effective remedy or not. Liens and foreclosure. So Hunter Brown is upset about rental restrictions and stops paying his assessments. Hunter has a unit that has $500,000 is owed on his first mortgage. So essentially, we're taking a look at a circumstance where we have a first mortgage on the property, we got some money owed, and what's the best way to collect when the association is owed assessments? So what's the best course of action if the unit is worth $1 million? What's the best course of action if it's worth $100,000? And would this change if it was a second mortgage or not? So the key facts and the things that you're going to take a look at here is if you're foreclosing and the unit's worth $1 million, it certainly makes sense. You're probably going to have somebody that's going to come along buy it. You can make a credit bid at the sale. There's plenty of equity. So by foreclosing, the owner is really going to have a good incentive to try and come up with the money, in order to, make sure that they can keep the property. If the unit's worth $100,000 and it's, underwater, the one thing you got to keep in mind here is that a first mortgage of record is going to have priority over the condominium lien. So if you, foreclosed, in this circumstance, you may not get anything out of it. You may just acquire title, subject to that mortgage. In that circumstance, what we did when the economy was bad is the association would basically acquire the unit and rent it out as long as they could until the mortgage company came along and foreclosed to try and recoup your fees. What if the mortgage was a second mortgage? So that's another important thing to take a look at, because only the first mortgage has priority. So if there was a second mortgage and the condo lien was recorded first, the condo lien is going to have priority, and you can wipe out the second mortgage. And why is that important? Because the second mortgage company, the bank holder of the second mortgage, is going to want to pay that mortgage off, pay the assessments off, not the mortgage off, but in order to preserve the mortgage. So the other things that you can get, you can go after people for money judgments. So if you think that they're collectible and it's going to be a situation where it is going to be underwater. You don't really want to rent it. That's fine. A lot of these situations we've seen now, the association will make a credit bid. They get the unit if there is no mortgage, free and clear, and then they just go ahead and own it and rent it out, or turn around and sell it. And they end up ahead of the game there. So that's a primer on liens and foreclosure. The key here is to make sure you have a collection policy. Make sure everybody is treated equally. They go through the same collection policy. The frequency of whether you're going to take collection activity or not is largely going to be dependent on your community, how much money you need. If your assessments are $500 a month versus $500 a year, that may make a difference as to, the frequency at which the association is going to put people through the steps. But the key is just to make sure that you have a consistent policy, it's being enforced, and that you make sure that you're collecting that regular income. In most cases, the attorney's fees get added on top of that, along with late fees and anything else. And that if you have a priority of payment provision in your documents, that those amounts get paid off first before the assessment amount as well. Injunctions, okay? So the condo bylaws require board permission to alter any of the common elements. Hunter Brown places a hot tub on his limited common element deck that is for his exclusive use. Hunter Brown hires an electrician to install a dedicated box to power the hot tub on his limited common element porch. The bylaws are silent on whether hot tubs are allowed. The association sues Hunter and seeks an injunction to remove the hot tub, as Hunter did not request permission to modify the limited common element porch or connect to the association's electrical system. Does Hunter get to keep the hot tub? So this is kind of, I guess, an interesting situation here. This was based on a fact pattern, was based on a real court of appeals case. And more or less what happened here is that the result was that the court said they tapped into the power box, the general common elements, in order to hook up this limited common element power box. And even though it didn't say anything about hot tubs, it's that there was a modification to the common elements. It may have been his limited common element for his exclusive use, but the bylaws required permission from the board in order to modify any of the common elements, whether limited or general. So that basically what the court said is that the hot tub's got to go in that circumstance. Money damages. So after his short-term rental business is closed, Hunter opens a recreational marijuana business. Condo bylaws prohibit illegal activity, but Michigan has decriminalized marijuana. Hunter plugs his grow lights into the common element hallway electrical outlets to save some money on his new business venture. Association's electric bill increases $10,000 a month. So a couple of issues going on here. One, can Hunter grow marijuana? And two, how can the association recover the $10,000? So in this circumstance, with respect to marijuana, it's just an issue that we get a lot lately. A lot of documents don't have provisions related to it. You can certainly outright ban it. If you don't have an outright ban on it, the position that we generally take is that it may be decriminalized under state law, but it is still illegal under federal law. So the association still has the right to enforce that as an illegal activity. And so that's the way that you would go ahead and enforcing that. In this circumstance, it kind of deals with the association is out of pocket because of this bylaw violation. So the documents do allow you to recover monetary damages and recover the attorney's fees on top of that. So this would be an example of a situation where you might go to court and ask for an injunction to make them stop growing the marijuana, but also for money damages to make you whole for the electric bill that resulted from the bylaw violation. All right, so moving on to Herzl's hurtful mistakes to avoid here. So we're going to kind of go through the, I guess, the basic provisions or basic, problems that I see are most common things that, kind of slip associations up. And then we'll go ahead and move on to just open it up for the questions that came up in the chat, as well as opening up everybody's mic and me just answering questions that way. So what are some things to take a look for that, we haven't necessarily covered that frequently come up? So quorum is a big one. Virus Valley, they have 100 units. The bylaws state quorum is 50% of the co-owners that are in good standing. All co-owners are in good standing. 48 people show up to the annual meeting. The association proceeds with the meeting. Donald Bump Jr. and Ivana Fair election. are elected to the board at the meeting by a razor-thin margin. Jojo sues and says the meeting was invalid. Will the court order a new election? What if somebody made a motion to waive quorum? Does that make a difference? So just a couple things here that is a general rule. If you don't have quorum, you cannot have a meeting. You can't take action. So this was not a legal election here. So Jojo would probably win this. The court would probably order a new election under this circumstance. If you don't have quorum, don't take votes on things. A lot of times what I'll see is people will have informational meetings and they'll kind of go through the presentation that they're going to make to the community to keep them informed. But you cannot take votes, and what the law basically says is that the directors continue on until the next time that you're able to have a meeting. So your options are that you can recall it and try and get quorum at a later date. And if you have not had a meeting within the last 15 months, the court can order a meeting to take place. And if they do that, they can order whoever shows up to be quorum. But that's not something that you could do on your own without a court order. The other mistake that I see often made is you get there, you don't have quorum, somebody raises their hand, you haven't even started the meeting, and they say, I make a motion to waive quorum, and somebody seconds it and it's waived, or they will just try and adjourn the meeting and come back and just do it again right away if they have a reducing quorum requirement in there. So that's not going to work. You can't, if the bylaws require, once again, stick to what's in the governing documents. If the bylaws require a certain amount or number for quorum, that's what it's got to be. You can't vote to violate the bylaws. All right, audits and reviews. So this is kind of a big thing that's come up in the last few years. Donald Bump is concerned that Jojo is mismanaging the association's finances. He demands the association perform an audit. Joe Manchin and Kristen Cinema indicate an audit would cost $4,000 per year and that an audit is not required by the condo bylaws. Being good corporate stewards, they obtain a compilation for $500 instead of an audit and send it out to the co-owners. Donald sues the association for an audit. Who wins? So to some extent, if you're a condominium, there's going to be certain requirements. Homeowners associations is going to be strictly governed by the documents, but condos are also, it's going to depend on what's in the document. So a few years back, there was an amendment to the Condominium Act that basically said that if you have in excess of $20,000 in revenue, that you need to have a audit or a review by a CPA on an annual basis, unless on an annual basis, the association votes to opt out from having it. So in this circumstance, Donald would win. One of the reasons he would win is because they only got a compilation. So when you take a look at financial statements, they really come in three forms. So a compilation basically says that you gave some information to an accountant. They made it look pretty. They did not verify anything about it, just put it into the format that looks like a financial statement and spit it back out without even really taking a look at it. So that does not satisfy the statute. The only way that you can do that is if you actually vote to opt out. What would satisfy the statute is if you had a review. Those are typically going to be cheaper than an audit or expensive than a compilation. And a review is that they will not do a deep dive into your documents, but at least the CPA will provide an opinion on a high level overview of looking at the documents as to whether there's any financial irregularities or anything like that. They're not going to get down into every single receipt, verify expenses, things like that. It's just going to be a general overview at a higher level. The audit is they're really going to dig deep into all the different expenses, verify the receipts, that kind of thing. It's much more expensive, much more costly. Some documents will actually require that. If you do, you may want to consider amending those so you're just doing reviews or at least have that option. So if you're in a homeowners association, you're not required to do that unless it's something required by the documents. If you're in a condo and you have more than $20,000 in revenue, keep in mind that you are subject to that provision. Record inspections. So this is something a lot of boards commonly deal with. Is you have people that show up to the property management company or come to the board members and they want to see every little record of the association. So the example we have here is we have Donald Bump. He wants a full investigation of the association's expenditures. He claims that Jojo is improperly involved in Hunter's business dealings. Donald attends the next board meeting and demands the board email copies of every receipt for every expenditure that Jojo made during his entire tenure on the board within 5 business days. Donald claims the Nonprofit Corporation Act allows him access to all the books and records of the association. Does the board have to produce the records? So the record inspection requirements, it's important to be familiar with that. So part of this is accurate, and Donald is accurate on, is the 5 business day requirement. So you don't necessarily have to produce them to make them available within the 5 days, as long as you respond and indicate, yes, they are available, and here is when they are available. There are certain records that you'd have to mail out, which is basically just the most recent financial statement, if they request that in writing, and there doesn't have to be a proper purpose for that. Beyond that, generally, for the most part, for what he's asking here, the Nonprofit Corporation Act would require him to identify a proper purpose in writing before having an inspection. What the case law says is that idle curiosity alone is not enough to justify an inspection. And so, if the co-owner does not outline that in writing and then give you the 5 business days to respond, that's not a valid request. You don't have to send them boxes of documents and stuff. What it says is they can come and inspect it. They can make copies at their own expense if they want to do that. So the problem for Donald in this scenario is he did not make a written request. He did not identify what the proper purpose for the inspection was. And so for that reason, he would probably lose. All right, so next thing we have here is Fannie Mae, Freddie Mac approval and financing. So Virus Valley is an attached condo with 100 units. 20% of the units are delinquent. The association receives an engineering report from a structural engineer indicating the building has minor concrete cracking that can be patched, but the building is generally structurally sound. Well, Fannie Mae, Freddie Mac purchase mortgages from this condominium. So this has really become a hot button issue since Surfside. And so going through this example, in this circumstance, the association would not qualify. They wouldn't meet Fannie Mae and Freddie Mac guidelines. The reason why they wouldn't meet it is because they both have a 15% delinquency rate. So if you don't keep a good handle on delinquencies in your condominiums, then you are not, that's just one of the basic requirements they had before Surfside. The thing that was just recently instituted in this circumstance would still probably pass muster, is they are going to take a look at the structural report, whether you've had reserve studies, providing those, whether there's meeting minutes, whether there's repairs. So if you have major structural repairs to buildings and things that haven't been done, then you're not going to meet the Fannie Mae, Freddie Mac guidelines. You won't be able to get mortgage lending. They've actually attached a somewhat convoluted questionnaire to the standard Fannie Mae, Freddie Mac questionnaire that we're starting to deal with our associations right now, where you have to answer these questions. They will look as to whether you have special assessments. If you have special assessments to fix repairs and they haven't been fixed yet, and you don't have anything to certify that it's been fixed, or if you have building violations, they will not allow lending in your condominium. Basically what that means is that your units you're going to have cash buyers for the most part, and it's really going to decrease the pool of potential buyers. The other thing to keep in mind about this is something you should be doing. It's generally required by the documents. And so you need to do it for safety purposes as well, in order to not just to meet the Fannie Mae, Freddie Mac approval requirements. But just keep in mind that a lot of boards they'll kind of have a natural tendency that it's unpopular to raise assessments, or that we shouldn't be spending money on certain things. But your primary responsibility is to operate the association appropriately, make sure that all the common elements are maintained, that you're doing your job there, and that you're not just trying to run the association as cheaply as possible or kicking the can down the road to the next board, because it's going to start, in addition to the safety consequences, it's going to start having real consequences as to the value of your property, and that can lead to lawsuits and other issues with co-owners. So it's really important that you're on top of that. You're getting regular reserve studies. You have a plan in place, so it's not too painful that you're spreading the assessments out over time, or getting a community association loan to making sure that everything gets done, as opposed to just putting your head in the sand. All right, last thing before we start getting into questions here and answering the questions is fair housing. Just tell you, this is tricky, and I've just seen a lot of associations, run into stuff that's kind of, defies common sense. One of the forms of discrimination under the Fair Housing Act is familial discrimination. So in this circumstance, Virus Valley reopens the pool after the COVID-19 pandemic. The board adopts rules requiring that any child under the age of 3 use the kiddie pool, and any child under the age of 13 be accompanied by an adult when using a large pool that is 10 feet deep. Hunter complains the rule discriminates against families. Is Hunter correct? So if you have amenities, basketball courts, tennis courts, pools, stuff like this, it's not infrequent that I see something that's in here that's going to be common sense for safety. Of course, we want to, make sure that, kids are safe, and that kind of thing. So, unfortunately, federal court judges don't always see it that way. What they have basically said is this could be deemed a form of familial discrimination, that, somebody who is 12 years old could swim better than somebody, who's 40 years old or 90 years old. And so that you can make rules that are based on, somebody's, swimming ability, but if you're basically making, supervision type of restrictions that are targeted, at children, or seeing that children, can't use the basketball court or something of that nature, that you can be subject to a fair housing violation, and that you're treating people with families differently by not allowing them to use the amenities in the same fashion as everybody else. So just keep in mind, this is a real thing, especially I see a lot if you get requests related to emotional support animals or pets, just discrimination claims, hostile environment claims, allowing, co-owners to basically duke it out when it becomes issues related to protected class or religion, ethnicity, race, that kind of stuff. Associations are more commonly starting to get into trouble regarding those issues. So this is definitely a circumstance that, may seem like common sense, but this is an important time to consult an attorney, because there's some very real penalties that can be associated with that. So before we go ahead and open it up with questions, just last thing, if anybody's interested, I've written a book. It's called Herzl's Handbook. It's available on Amazon. And here's the link right here. It's just kind of a general guide that I wrote to be short, simple, easy, that you can use as a reference, take it to your board meetings, and be able to, quickly answer questions as well there. So that'll kind of give you the basics in addition to the presentation today. So John, if you want to go ahead and unmute yourself, and we can start playing Stump the Lawyer and see how far we get with that one.
All right. Well, thank you for all that. Got quite a few questions. I'll just read them, and I don't know if we need clarification, maybe we can find whoever sent them in. But this one's from Matt. It says, our association bylaws require a written request and board approval to transfer limited common elements, garages in our case. Our bylaws do not require assignment changes to be recorded via a amendment in our master deed. The board maintains the assignments. Is this a problem? And what will likely happen if a co-owner sues the association to reclaim an assignment that was recorded in our original master deed in 1979?
So this is one I'd need to see the specific documents on to give you a good answer. I can give you some general guidelines though. If you are changing what's a limited common element or a general common element, or who it's assigned to, generally speaking, that means that you need to have that in the master deed, and you need to have that recorded in an amendment to a master deed. One of the common things that I will see is like with parking spaces, for example, they may be deemed to be limited common elements. And, those actually, so I see people try and deed those, but you do have to have an amendment to the master deed under the Condominium Act, to change parking spaces around, for example. So the situation that you described there, I would just say, generally speaking, it does not sound quite right. I've seen circumstances where people have sued over that and said, I'm still entitled to this parking space versus, another parking space because that correct procedure wasn't followed. And so, what I'd recommend is just getting an opinion from, an attorney, whether it's me or somebody else, as to whether or not this is right and what's the best way to go ahead and do some amendments to maybe fix it up. But just the way it was described, it doesn't sound quite right.
All right. Next question. I think I actually know this one, Kevin. So,
All right.
yeah. I believe it's Susu Ma asked, do we need 2/3 of co-owners votes to change the bylaws? And that is that in the Condo Act, or is that just in bylaws? I know it's 66.6%. Could it be different between bylaws and the Michigan Condominium Act, or is it just across the board 66%?
No, it's for condos, it's across the board at the 66 and 2/3. So that's in the Condo Act, so you can't, increase or decrease that percentage. The one thing to keep in mind, though, is that's for material amendments. Occasionally, like if there's a typo or something like that, the board can have the authority to do what they call a non-material amendment. It's very rare, and there's only a couple of cases that have actually deemed something as a non-material amendment. So it's not something that I commonly like to do. But pretty much just about every kind of amendment that you're going to do will require that. But there's other ones, for example, like switching the parking spaces that we talked about. It specifically says in the Condominium Act that the board can just approve that.
Okay.
But for the most part, it's statutory, and you're going to be at the 66 and 2/3 for that.
Gotcha. Okay, so another one from James. The master deed restricts short-term rentals to not less than 6 months. What are the steps to enforce this? Are there legal costs assessed to violators? So how do you, I believe how do we enforce a 6-month rental?
So this is one thing that we've had, I guess, quite a bit of success with doing here. In every circumstance is a little bit unique, but generally speaking, we will send them a demand letter. We will tell them to stop renting. Under the Condominium Act and most condominium documents, you are actually allowed to evict the tenant as one of the remedies. So as long as you give them at least 15 days notice that they're in violation of the bylaws, you can do that. Generally speaking, we also recommend getting an injunction against the co-owner or a court order that says they can't continue to rent anymore. And so if they don't respond to the bylaw violation, the next step would be to take them to court to evict the renter and to get that injunction to make them stop. To enforce that. If the documents permit you to recover attorney's fees, which most of them do, that would also be added onto that and would be recoverable as well. And so it's, I guess, good, bad, or otherwise, I would just say that it's a very common issue now, one that we're facing quite a bit. I mean, just last week when the association came to us, and I think they had like 6 to 8, rentals that violated a very similar provision. And we started by sending letters out to everybody and started that process. And so some people are more apt to comply, and once they get the letter, they'll come in line, and you don't need to have a lawsuit. And we have other people that, they may be financially underwater and may cut, they'll try and fight this tooth and nail. But if you have clear governing documents and you can't do that, then that would be the appropriate remedy.
Gotcha. See, another one from James. I'm not sure if it's the same James, but does the board have to allow for individual co-owners to listen to board minute meetings via Zoom? And I think to expand on this too, our co-owners, is the board required to let co-owners in a regular board meeting? Can they listen into a regular board meeting? Do they have a right to be at board meetings?
So legally, they are not required to let them be in there unless there's the bylaws specifically say they can attend. Most bylaws do not say that. So just keep in mind that, if you have somebody from a different state, the Open Meetings Act does not apply to board meetings and nonprofit corporations here in Michigan. It only applies to public entities. In other states, the Open Meetings Act would require the owners to be able to attend. So typically what I recommend is that you don't necessarily just want to completely shut owners out, because if they're unheard, they're not necessarily going to be happy. So you probably, a general rule of thumb, if you have a good hour for board business, you don't want to have interruptions, be dealing with co-owners. You want to have a schedule, get through it, have votes, make decisions. that, whether it is to have an open forum type of thing at the beginning of the meeting or have something separate from a board meeting, if people, want to come and give feedback or let the board know something, to go ahead and schedule it that way. So you can have, efficient board meetings. I mean, I've been to my fair share of 4 and 5 hour board meetings, and I don't think it's an enjoyable experience for anybody. So
No. Next one, what if an association only has 2 of the 3 officers and no one else wants to volunteer? We see this a lot too, where just no one wants to volunteer for a board. So what happens if no one wants to run for the board?
Well, so, I mean, legally you're required to have a minimum of 3 directors. The Nonprofit Corporation Act doesn't necessarily contemplate what happens if you fall below that, other than most documents will indicate that the people that are the directors, they just carry on and they continue on with the business until they can find somebody else. If you get into a situation where you literally have no directors and officers and they're all gone, typically what's going to happen there is somebody will file a lawsuit at some point in time to say, court order this, I want to take this over, or to put the association into receivership. And so basically, then you're paying a receiver a lot of money to operate your association because you don't have anybody to volunteer to do that in your community. Which would make your community to be it's just a lot more expensive. It's not a good solution. The owners are not, having really input into the process, and they're paying a lot more money to have a stranger run their community.
Gotcha. So this one is, I believe I know this one. Speak to the reserve requirements for condo associations. Since the condo collapse in Florida, what are the requirements in Michigan? So I don't know if this is the kind of the same thing as the bylaw one. I don't know if it's a Michigan Condominium Act in that, or if it's just in every bylaws that I've ever seen, is they have to have 10% of their operating budget in reserves at all time. Is that the Condominium Act, or is that in just bylaws?
Yeah, so that's in the Condominium Act and in the administrative rules that go with that. So in Michigan, it's 10% on a non-cumulative basis. Okay, that doesn't, the minimum legal requirement doesn't mean that you have to put in 10% every year. Fannie Mae and Freddie Mac, though, when they're taking a look at this, they want to see that you have that 10% there in your budget every year that's being put away. One of them will allow that requirement to be waived based on a reserve study, which I believe is Freddie Mac. The other one will not. And so my just recommendation moving forward is, even if you aren't socking away 10%, even if you're not legally required to on a non-cumulative basis, that you should just be putting away at least 10% each year and building that reserve. It's really important, though, and kind of what they're looking for is to get regular reserve studies to figure out 10, 15 years from now, am I going to have to replace roads, roofs, structural issues, that kind of thing. What they want to see is the association being fiscally responsible? Do they foresee this? Do they have a plan? Or is the building just going to collapse and crumble, because Surfside had all these problems and they just couldn't come together to figure out, how to fix it and move forward. Or at least, that's what appears to be the case, because the lawsuits are still ongoing. But so as a general rule of thumb, you really want to, the 10% is probably not going to be enough to do everything that you need to do. So I highly recommend getting a reserve study, even if it's not legally required. And even some associations, if it's not required here in Michigan yet, it's possible legislation may be coming through that could require that. A lot of states are starting to look into that, making reserve studies mandatory. You could still put it in your documents as a best practice if you want to do that as an update, which really kind of forces the board member to do it irrespective of who's on the board.
Gotcha. And I think almost everyone here knows, unless you haven't gone through budget season with Cummings yet, but we basically have something on our budget worksheet at where the signature is if it's not 10%, they have to sign off that it's not 10%, because we want to make sure everyone puts in 10% every year, just so they have a contingency fund, worst case scenario for that too. So we want to see people stack up their reserve funds. So and another thing on reserve studies, I was thinking about doing one of these webinars for reserve studies too. So I still think we should probably do that soon, just so board members can see a sample reserve study and why it's a good idea and all that. So, let's see, any recommendations regarding a condo owner exhibiting mental health issues that are impacting neighbors?
Yeah, I mean, typically in that situation, I'd recommend calling Adult Protective Services and seeing if you can then, have them come and investigate. They may make a recommendation or try and actually go to probate court and get a guardianship or a conservatorship, for that person is typically the best way to handle that. If there is some sort of bylaw violation, I mean, your job is really, to some extent, if you can be compassionate, and try and handle it. I mean, that's great, but if they're causing danger or a threat to somebody else in the community, I mean, you're going to have to make sure that either you call the police or take some sort of enforcement action, get an injunction, take them to court, I mean, yourself, to prevent them from endangering anybody else in the community.
Let's see, can proxies be collected after the meeting with elections to ensure quorum is met, even though it's after the fact?
Nope. So basically, in order to check in for meetings and what the standard is for voting is, during the meeting, you can decide, at a point in time that you're going to stop collecting ballots or not collecting ballots, but you can't collect, even a ballot after the meeting. For proxies, you have to have that at the beginning of the meeting to know if there's quorum or not and who's involved in the meeting. So you can't be collecting proxies or ballots after the meeting.
Yep. And we had it where some meetings where we count the proxies and the whoever's there at the sign in and say, hey, we don't have quorum. We might sometimes we go over some of the people went over financial stuff just for the people who are there, but basically
we do that. And then my favorite thing is just, when you're 2 or 3 people away, you got everybody's on the Zoom. Yeah, you got and they're coming to the clubhouse or text them to get on the Zoom or whatever. Yep. So, that's another way to do it. You just delay the start of the meeting. Yeah.
And then, I mean, on the same topic, like, and it probably depends on each bylaw, but when you don't have quorum, that's not in the Michigan Condo Act about meeting again, right? I hear some associations have like, what do they call that? The deducting quorum or whatever.
Reducing
so the
quorum?
Next time
Yeah.
it's, yeah.
So it's not in the Condo Act, it's in the Nonprofit Corporation Act.
Okay.
It basically just says if you don't have quorum and you can't have a meeting, then the court can order it and they can say whoever shows up as quorum.
Okay.
For bylaw amendments, what we typically recommend to just avoid that problem, if you can do a document amendment, is put it in there that it reduces by half each time you recall it until you actually get quorum, because then you don't have to go to court, get the judge involved, any of that kind of stuff, and you can just do it on your own.
Because I mean, really, really, they could just keep meeting and meeting and meeting and never have quorum, and it's just kind of.
I mean, I got some associations, they have not had a valid association meeting in like 10 years because they can't get enough people to come.
Yeah. All right, let's see. Joel asks, what kind of recommendation would you make for a association taking a strict bylaw enforcement after many years of neglect of the bylaws?
So a couple things on this topic. Generally, what I recommend is before you don't just necessarily fire it off with the attorney right away, unless it's in some sort of an imminent type of issue. I send a letter out to the community, not necessarily targeting everyone, saying, hey, just so you know, in the next 30 or 60 days, we're going to be looking for these issues or these types of issues, we're going to start enforcing. So you need to be aware of this, that way you're not going to have necessarily a huge uproar. It gives some people time on their own without having legal involvement, to try and make things right and move forward, that way. If that doesn't work, certainly turn it over to the attorney for a bylaw violation letter. We've had a couple Court of Appeals cases that we've been successful in a situation where the documents just haven't been enforced for a long time. Most documents are going to have what they call an anti-waiver clause that basically says just because we haven't enforced it in the past doesn't mean that we can't enforce this in the future. And the courts relied on those in these bylaw enforcement cases. So that's a good tool. But the other thing just to keep in mind, establishing waiver of restrictions, it's very difficult in Michigan. And it really has to be, something that's very widespread, amongst the community, or you can show that there's been a significant change in the community over a long period of time. And so it's just, it's going to be a culture shift, but legally speaking, it's not generally a heavy lift.
Gotcha. All right, next one, Derek from Derek. The board voted down a modification to a architectural request, and now the board wants to have another vote on it. So can they vote again on a architectural control? I don't know if maybe they got more information on it or.
Yep, there's no reason. I mean, it would just be resubmitted, and then the board would have a vote. If there was additional information or changes, that's perfectly okay.
This one from James. What's required regarding a reserve study? I'm not sure if he's asking what do they need. I don't know what you can say to this, Kevin, but I know I just went through a reserve study with one of my associations. They needed, obviously they need the bylaws to see who's responsible, what the association is responsible for. I met with the reserve study specialist on site. We walked around, and a couple of special issues. What were, here's the fence that we're responsible for. So we met on site with them. I gave them our current budget, our past budget. We gave them the current financials, what's in the operating account, what's in our reserve account, stuff like that. I believe that's what James is asking. I don't know if you know any more than that, Kevin, but.
No, I mean, there's no legal requirements, here in Michigan for them. There's just not a lot of people that even do it here in Michigan. A lot of the people, they come from out of state. So through the Community Associations Institute, they have a certification that they give to people that have done, so many of these. Is one way you can tell whether these people are legitimate or whether they have experience in doing that. And generally speaking, what you outlined is the process to look at the governing documents. They'll take a look at your current reserves. They'll take a look at conditions. They will make projections into the future as to what the useful life is and what it will cost based on inflation or at that point in time, and give you just an idea of how much you should be saving over time in order to make sure that gets taken care of.
Oh. Yeah, I'm sorry.
The one thing I do want to clarify on that, that's different from Surfside is if you talk to almost any reserve study specialist, they do not take a look at the structural components of the building. So a lot of people think, I can just get a reserve study and that won't happen to me. More or less what the new standard is and what they're putting out there for these guidelines is that the reserve study specialists are going to advise you to go get a report from a structural engineer who will take a look at those structural requirements. Yep. And I think you're going to start seeing that, moving forward. I don't know that you necessarily need a report from a structural engineer every 3 to 5 years like you do, from a reserve study specialist. But especially, once your condo gets to be 30, 40 years old, you should probably, take a look at that, especially if it's going to be a high rise or you have multi-stories. It's really less of an issue, if you're in a site condo or a duplex or you only have like a couple floors or something. The odds, are significantly less that something bad like that would happen.
Yep. I do know what it came up with one of ours too, is they did a reserve study and they found out there's a huge expense coming up, and they ended up amending their bylaws to put that expense to co-owners. It was windows. So they switched the responsibility from windows from the association to co-owners. And it was basically all because of the reserve study showing how this huge expense is coming down the road. They would have had to raise their fees. I think it was $90 a month just to pay for these windows coming up. So the board thought it was best to say, hey, you guys decide when you want the windows. You don't have to pay for your neighbor's window. So that was a good use of reserve study that specific time too. So, and obviously everything else that came with it, but. Okay, so from Maggie back to scene record. If a owner feels that contractors are not completing work and possibly overcharging, is this where they have to put in writing their request to see association records? Yes.
Yes, that would be for basically the proper purpose, and to review, I guess, that contract and the billing and that kind of thing. Yes, I mean, that's how that would work.
Okay, and then another one, let's see, from, I'm not sure, Shannon, I think. You stated to be sure to maintain your volunteer status. So can a board pay one of its board members to be the treasurer or waive the association fees or exchange for being a treasurer? Or does that affect the paid treasurer's reliability potential of not being a volunteer? I'm shaking my head. Probably, I don't know, maybe it depends on the bylaws, but I don't.
Yeah, so some bylaws will say that the board can vote to compensate officers or directors, or the members can.
Yeah.
But just my advice is I wouldn't do that, because you are correct, ask the question to point out you lose your volunteer status then, which is essential for maintaining those liability protections. And the little amounts you're going to get off the dues or whatever for doing this, if you got sued in a lawsuit and you didn't have that volunteer status, you're going to have major exposure there, and so it's just not worth it.
No.
Most co-owners and other, they're just not going to like that and think it doesn't smell right, even if it is permitted by your bylaws. So there's a lot of good reasons not to do that.
Yeah. People already get it. A lot of board members get enough gruff as it is, and you add paying them to it. I can imagine gets even uglier sometimes. So, is there any rule that board members can't get together socially without discussing any condo business? I've heard there is, Florida has strict laws against this. I don't.
Yeah, so that gets into that's an Open Meetings Act question again. For example, I was on a school board before, and so that's subject to the Open Meetings Act. Public entity, and so we couldn't get together to discuss business, and make decisions outside of the meeting. That does not apply to condo board members, directors, and nonprofit corporations. You're all allowed to be friends, so you can get together without violating the law.
Yeah.
And decide whatever you want. And we kind of went through the different ways that you could take, even unanimous email consent, would work. So,
yeah. All right. If the association wants to make a common element into a limited common element, what type of votes do you need, since every owner owns an equal share of the common element?
So it's going to be the 66 2/3, but the issue there is if you are assigning something that's a general common element to a specific unit as a limited common element, you need the consent of that particular co-owner who the limited common element is going to be assigned in order to do that. So that would be the only extra caveat in that situation.
Okay. All right, this is the last one so far, unless another one pops up. But if a co-owner requests a modification that is not directly prohibited by the bylaws, can the board vote it down based on aesthetics?
Generally speaking, yes. It depends on what the standards are for approval in your documents. And what you're supposed to evaluate. A lot of times that's laid out. A lot of bylaws will also have provisions that basically say, this is in the sole discretion of the board. The board members, they have no liability. They can make whatever decision they want. And so that's fine. If you don't have that type of provision, people may come after you if they say it's a selective enforcement type of thing, or that you're being arbitrary. But for the most part, yes, you do have that authority unless there's something that prohibits you or says that you have to follow a certain set of guidelines in the bylaws.
That was the last question. I don't know if anyone else has questions. If anyone's,
I have a couple of questions. I think I sent that to Kevin. The one question I had was the contracts. If there is some work needs to be done, and the signing the contract by the management company versus the board members. Are there any laws or rules that, signing a contract, or if there's some kind of amount determines to as well? What would you suggest?
Yeah, there's not necessarily any laws by it. It's really just a matter of how you want to set up your association to run. So sometimes the property management contract will say, the manager has authority up to a certain amount, or that they can assign, sign contracts. For larger contracts, when you're approving those to the board, if that's not something you previously approved as part of that contract, in the board resolution, you can just identify, or the meeting minutes identify who signs it, whether it's the agent on behalf of you, or you want to have the board president do it. I mean, that's fine too. Either way works, as long as it's something that you guys voted on and documented who that signer is going to be. But an agent has authority to bind the association, or you guys designate one of the board members or officers to be the signer.
So property management company they can act as an agent as long as during the meeting board members approve that amount to be paid to this vendor.
Yep, as long as you give them authority to do that, either in a contract or a vote, they can go ahead and do that. So, some associations will say, hey, I don't want you entering into any, like if it's less than $5,000 or it's just an immediate emergency repair, like I'm going to give you authority in the contract to just go do that. Others will have like dollar amounts in it. My guess is, I know John well enough in Cummings. If they're going to do $1 million road project, they're not just going to go off and do that on their own. But still identify in the resolution adopted, who is going to have the authority to assign that and execute that, so there's never any question afterwards. And I mean,
Usually,
that's important.
Yeah, I was going to say, I don't think anyone here, and I think it's a kind of our practice not to sign anything over, let's say, $1,000 contract, because a long contract, long mowing, snow removal contract, we want the board signature on that. A roofing contract, we want the board to make sure they sign that, just so they. I don't know if it's a liability issue or whatever, but we feel more comfortable with a board member signing those big contracts. So.
I agree with that one. There are
Yeah.
some drawbacks as far as on the property management contract. There's a statement that, if, whatever the property manager, signs or something has no liability or nothing, something in regards to there's some kind of statement on the property management contract, I believe. But okay.
Yep.
I was talking about more like 20, 30, 100, $150,000 contract.
Yeah, I would think I would want us to have the board sign a board member, the board president, or whoever signed the contract, and not the management company. But, yeah.
Omer, that means you're going to have to come back from your beach hideaway there to sign these contracts.
I'm in Florida, Fort Myers, Florida.
Or how about no? I'll come down to you and I'll bring you the document and stay for about a week or two with you.
Okay, thank you. Thanks.
Yep.
Yeah.
A question came up here. If a crazy owner who is emailing residents and lying about what is going on with the board, what can you do about that?
I mean, to some extent, the nuisance, type of situation comes into play there. Send up a demand letter. You kind of have to be careful about it as a practical matter. I mean, you can certainly respond in writing if they're doing something that's a bylaw violation. You can go after them for that. Sometimes in the documents we will put in provisions that you're not allowed to circulate literature and all this stuff and place things on people's doors, which is annoying. Technically you're not, it's illegal if you're stuffing stuff in somebody else's mailbox, because if you're not a postal worker and doing that, that's not permitted. So there are different ways to go after that. Generally speaking, what I find, it's not always super effective to fight fire with fire, because that is just going to make the person even more pissed off, and then they're going to keep coming around. But if you invite them into a meeting and they're upset about doing something, start asking, like, how would you do this? What would be your solution for this problem? And a lot of times people just want to be heard. And so, as long as you can, it's not an easy thing to do. Like, nobody likes to be told that they're doing a bad job or they're wrong. And I get it. You guys probably know this better than most, that you don't get paid in compliments, and most owners don't come up to you and say, hey, you're doing a fantastic job. They come to you with the problems and the things that they're complaining about. But like just how you deal it on your own is sort of going to depend whether, I need to get involved and whether it escalates to me or not. And sometimes I've been pretty successful at just trying to diffuse those situations so they don't become lawsuits and something bigger, in that circumstance. But other times you just can't reason with people, and you need the stick instead of the carrot. So
Yeah. One more question that came up too. Previous rumors indicated that mortgage companies have to approve changes to the governing documents. You mentioned this kind of earlier too about, you said there's nine different amendments that a mortgage company has to vote on it.
yeah.
I don't know if you want to speak a little more on that.
Sure. I mean, it's sort of the two biggest things and the most common ways that we see it are going to be if you're changing rental restrictions, or if you're changing maintenance responsibilities. The rest of the stuff, it's typically a lot less common, when you get into terminating the condominium and just, other things like that. But, keep in mind for the mortgagee votes, we typically will send out a questionnaire. You are required to keep a book of mortgages. And everybody's supposed to be providing this information under the Condominium Act. It's probably somewhere tucked away in your condominium documents too. Most people don't keep up with it great, but if they don't, it could be a bylaw violation. But when we do the document amendments, we try and request this information. We send out the voter information package. And then, you do have to notify them, but, there's a 90-day window and most of them don't respond and it counts as a yes vote. So you don't need to get their affirmative vote. So that's not a rumor. It's just, the law as it relates to condos. And then whether or not, they have a vote, don't have a vote, that also impacts the lending guidelines as well that we've been discussing. And so, if your documents don't comply with the law and they don't require notice, to a mortgagee and provide them with certain rights, they may, not lend, and that impacts the property values in your condominium as well.
That's all the questions in the chat section. So,
Okay.
I think everyone will agree that this was very, very informational. So thank you very much, Kevin. It was great.
I will. I'll send you a copy of the PowerPoint. I'll send you a copy of this recording so you guys can have it and circulate it. If anybody wants to share this with any of the other board members, they're welcome to do that as well. And so thanks everybody for coming. Thanks to John and Cummings for having me. You guys had some great questions, and so I'm glad that you got some good engaged board members over there at Cummings. So it's good to see.
Yeah. Thank you very much, Kevin.
All right, take care, everybody.
Thank you everyone for joining us.
Thank you.